No alibi, bye. Say goodbye, bye. Don't ask why. I might die. You either fly, or you fry. Every try. You always lie. Every female, every guy. Don't try to escape and get high. Maybe for a minute, not even a second. Roll that blunt while you count your blessings. Rolled outside and pointed my weapon. Like Eazy-E on Ruthless Records. Just like I thought, the food kept stepping. Smell like shit from shit I stepped in. Look in the mirror and point my weapon. You so soft you won't do nothing. Wanna be starting something. Got to be starting something. Wants to be starting something. Got to be starting something. Get low and take you under. Hang high and make it over. Shoot yourself in the middle when the pain is thunder. No, fuck that shit. Smoke a blunt, it's the best I get. I live my life with no regrets. And so I'm stuck with the pain. Live my life with no regrets. And I'm stuck with the shame. That's paranoia for ya. Paranoia I didn't get over. That's paranoia for ya. That's why you're drunk, not sober. That's paranoia for ya.
Even published several original pieces of research himself, which I still treasure today. The typewriter and its relation to crime, the tracing of footsteps with some remarks upon the uses of plaster of Paris as a preserver of impresses, which was of great value in solving the case of the Sign of Four.
Such had been the success of the first story, A Study in Scarlet, that a second followed in 1890. The Sign of Four contained elements that were to recur in later stories. When intellectual stimulation was absent, Holmes sought the chemical alternatives. Watson recorded that Holmes's sinewy forearm and wrist was dotted and scarred with innumerable puncture marks. He alternated between morphine and cocaine, which he always took in a 7% solution.
Granta says there's supposed to be 7.
Your time is up, Mr. Lyman.
Raymond Lyman. Yeah, I got questions on from 5F to 5I about the Sabinas. Mrs. Evans, and you might answer this, and then let me speak to 3 minutes. You did it on the subpoenas. Wasn't it from 2001 to 2007 that you want all financial records from the Doherty office and all the departments, yes or no?
Yes and no. Actually, I said from January 2002
Oh, 2002.
to date. Mm-hmm.
And isn't it true that since Fanucci wasn't here, they all voted, they're all...
I leaned over and I said, Ben, when are you going to stop playing games with God? I led that man to the Lord right there. There's times that might be needed.
Sometimes I'm ashamed of how the whites draw back and use their intellect and miss the very blessings of God.
Hold this, Kurt. Behold, the atheist's nightmare.
Stand with us. I'm Bill O'Reilly in a personal story segment tonight. Today is a National Day of Prayer. It has been endorsed by President Obama, but there are legal challenges all over the place, and that, of course, is dumb.
The banana and the hand are perfectly made one for the other. You'll find the maker of the banana, Almighty God, has made it with a non-slip surface.
When you do that, I can't stand.
It's a new day in the rap game. Nobody sells records but Sean Poe, motherfuckers.
What up? This is Marlawn, a.k.a. Sherlock Homeboy, back like I never left, fast as a statue, being nosy, minding my business. What up, Sherlock homies, Sherlock Nation? Are you not entertained? If you like the episode anyways, please donate $2, or better yet, leave a 5-star rating, which is like donating $100. Welcome to Sherlock Homeboy, the podcast. Come on in, have a seat. All right, in a moment of transparency, I'm not really feeling good, but not really physically. I'm just pissed a little bit. How can I say? Okay, might as well just be honest. How can I say this? I'm not, let me think, how can I, well, just be honest. Marlawn won't put out the last 2 episodes I did. And I'm pissed. That's 3 hours for nothing. I'm not going back cover it. I'm just going to keep it moving. But I'm pissed. This is like boring content, so I turned up the fun meter. And after sitting in this chair for 3 hours, he said he's not going to post the last 2. This was last night, last 2 fucking episodes, because he didn't like them. And that's bullshit. That's bullshit. I'm doing this shit for no reason. That's bullshit. So since the fun police, it's okay when you tell me I'm doing too much. It's okay and stuff, but for me to do all that work just for you not to post it, that's bullshit. So, well, you want boring? I got boring. I'm gonna eat. I got my dinner, my lunch. I only eat once a day anyway. So, it is what it is. Well, here we go. All right, eat my fucking lunch, man. Don't worry. You don't have to worry about me trying to make it exciting. Fuck that shit, man. I'm already paying to do this. I'm gonna do fucking 3 hours worth of content just for you to show me you don't like, say you don't like it and not post it. Fuck that shit. So what I'm doing is I got you. I have to work on it not being a good episode. I guess I got to work on not having fun. This boring shit. Okay, I got you. I'm just gonna eat my lunch. Yeah, fuck it. This is Day 1, Part 3, audio from Lori Vallow Daybell trial jury selection. No, I'm not playing no music. I'm not having fun. I'm not. Nope. Day 1, Part 3, audio from Lori Vallow Daybell trial jury selection.
For the remaining jurors here, you have been passed at this time for cause, or any objections were overruled by the court, so you will be returning. We'll continue to question additional groups such as yours until we reach the necessary number of jurors for the attorneys to exercise their peremptory challenges. You're going to be instructed to contact the jury commissioner. We'll give you a card with his contact information. He'll be providing you additional instruction regarding when you will again be required to return, when we'll assemble the final group of jurors for peremptory challenges. While you are waiting for that, again, please bear in mind not discuss the case or investigate the case during this critical time frame, so that you can remain impartial in the case as we've previously determined. And if anybody is trying to contact you or for any improper communications, please note that and report that to the court. And I'll also have you complete that admonishment indicating that you have not researched or looked into the case since we last met, whenever that is, that you are instructed to return again. So that will conclude the voir dire for this particular group of jurors. Before they're dismissed with instructions to return, anything further from the state?
Nothing further, Your Honor.
Okay, from the defense?
No, Your Honor.
Okay. That will conclude this panel, and we'll take a recess here, and then we'll discuss our scheduling and where we stand for the day. I'll meet briefly with the trial court administration also on that issue, and we'll come back on the record here in about 15 minutes. Take a break.
All right, please.
See, you've got to skip it ahead.
We had intended to try to get to a fourth group today, but we're not going to have time to do that, clearly. We have groups lined up for tomorrow. So the group 4 jurors for this afternoon on my list started with a number 1782, and then the number restarted again, but ending with a juror number 389. Hopefully we're all looking at the same group for organizational purposes, but my understanding is the parties agree that we can allow those jurors to be put on a standby status and released for the day. We'll finish up with group 3 today, and then if we need to, we can recall group 4 at a later date. Does the state agree and stipulate we can do that at this time?
Yes.
All right. Does the defense agree as well?
Yes, Your Honor.
Okay, counsel, and I'll also just indicate on the record, given the random nature of how their juror numbers were assigned, does the state raise any objection to the manner in which we're seating or calling the jurors, given that we're going to change that schedule?
No.
Does the defense raise any objection to the manner or method in which we're impaneling or seating those jurors on that list?
No, Your Honor.
Okay, thank you for your cooperation on that, counsel. As I mentioned, then tomorrow we'll plan on doing 3 groups like we did today instead of 4 to allow adequate time for your voir dire. We'll have groups tomorrow tentatively scheduled for 9 o'clock, 11, and 2 o'clock, and we can discuss that more on the record tomorrow. With that in mind, then, we'll bring up our final group of jurors, group 3, and have those jurors brought in at this time for voir dire. Matters. There is a courtroom conduct order. In effect, these proceedings are being simulcast to 2 separate viewing locations, one in Ada, one in Madison County. The use of electronic devices to record or photograph or transmit any sounds or images from those viewing areas is prohibited by that order, and the bailiffs are authorized to confiscate any devices used to do so. I'll also note that the court received the juror affirmations from each of the jurors in this group, indicating that they've complied with the previous order once they were released after they completed their questionnaires. So we appreciate you following those orders and completing those affirmations. At this time, then, I'll finally advise counsel again, remind you to only refer to jurors by their number, what we call the red card number, because that's the number on the red card that you have. And we'll take a roll call at this time to ensure who's here and determine who's not. So, Madam Clerk, if you would start with the roll call. All starting on the front bottom row, lowest number will go in ascending order to the second row.
When I call your juror number, if you could please answer off for the record. Juror 1106. Here. Juror 1133. Here. Juror 1210. Here. Juror 1238. Here. Juror 1266. Juror 1273. Juror 1276. Here. Juror 1323. Juror 1370. Here. Juror 1527. Here's the FTA. Juror 1569. Juror 1571. Juror 1589. Juror 1658. Juror 1758.
Okay, thank you all. If anyone is contacted or hears anything from Juror 1527, please advise the court. I will admonish that for their non-appearance, they could be subjected to contempt under Idaho statutes 7610 or 22085. We'll take that issue up at a later time with that juror who has failed to appear. Ladies and gentlemen, thank you for returning back this afternoon. We appreciate your patience. I know you've been here for some time. You've been recalled in this case as prospective jurors now before us. I'll reintroduce you quickly to the staff that's assisting today. I'm Judge Stephen Boyce from Fremont County, and I'm in charge of the courtroom in this trial. The court clerk seated to my right is Shannon Holstein, who keeps minutes of the trial proceedings and marks trial exhibits and administers oaths. There are bailiffs here assisting us, Deputies Ravello, Holmes, and Beish. They'll help with the courtroom order and assisting in moving the jury around. The court reporter, Patty Bath, takes a stenographic record of everything said in the proceedings, and then my staff attorney is Courtney Stallings, who's seated at the table over by the window, and she will assist me as needed with legal issues that may arise during the case. Each of you is qualified to serve as a juror of this court, and you've filled out a questionnaire that's now been reviewed by the court and the attorneys. This is the process of selecting 18 jurors altogether, which is 12 jurors and 6 alternates from among the group. At this time, we've already gone through the roll call and indicated we had one juror fail to appear. I'll again advise you of the jury selection process and reintroduce you to the parties and their lawyers and summarize briefly what the case is about. When I introduce an individual, please stand and then face the jury panel, then you can retake your seat. This case has been brought by the state of Idaho. I'll sometimes refer to them as the prosecution. The state's represented at this trial by Lindsay Blake, the prosecuting attorney for Fremont County, and by Rob Wood, the prosecuting attorney for Madison County, as well as Rachel Smith, special prosecutor appointed in this case. The defendant in this case is Lori Vallow Daybell, who's represented by her attorneys Jim Archibald and John Thomas. Thank you, counsel. This case is a criminal matter. That the defendant has been charged by the state of Idaho with a violation of the law.
Donations from Sherlock Nation is the gas station of this operation. For me to stay subscription and paywall free and to keep my commercials at a minimum while helping me stay independent and focused. My address, PayPal, Venmo, and Cash App is in the information box. Leaving a 5-star review will help just as much. It takes a cult to raise an independent podcast. The only way I can fail is from lack of support.
When you were last here to receive your questionnaires last week, I read in detail from the indictment the charges that have been filed in this case. Reiterate a brief summary of what's been filed in the indictment in this case. With regard to the defendant, the state of Idaho has alleged that the defendant, Lori Vallow Daybell, committed the crimes of count 1, conspiracy to commit first-degree murder and grand theft by deception, count 2, first-degree murder, count 3, conspiracy to commit first-degree murder and grand theft by deception, count 4, first-degree murder, count 5, conspiracy to commit first-degree murder, and count 7, grand theft. The defendant has pled not guilty to all of the charges. And please remember, this is simply a description of the charge. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means 2 things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove her innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. I'll next address the juror's duty in this case. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I'll later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be or what any lawyer may state the law to be. During the course of the trial, including the jury selection process, you're instructed that you are not to discuss this case among yourselves or with anyone else, including any use of email, text messaging, tweeting, blogging, electronic bulletin boards, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, then, I'll ask that the court clerk swear the entire jury panel for this voir dire examination. Ladies and gentlemen of the jury, if you would please stand and raise your right hand, I'll have you placed under oath.
Do you solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as trial juror in the cause now on trial? So help you God.
Thank you. You can be seated. Will the state stipulate that the jurors are now properly called, impaneled, and seated?
Yes.
Will the defense also stipulate that these jurors are properly called, impaneled, and seated?
Yes, Your Honor.
All right, thank you, counsel, for that. I'll next discuss the nature and purpose of voir dire. In this part of the jury selection, you'll be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to the origins of common law. In Old French, it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand that this questioning is not for the purpose of prying into your affairs for personal reasons, but is only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, please raise your hand. And at this stage also, I'd say raise that red card, which helps us identify who you are. And when you're called upon to speak, also, you can just identify yourself by raising that card, please. These proceedings are being recorded stenographically, so when asked a question, please make a verbal response, such as yes or no. Try to avoid saying or nodding or shaking your head, because then the record doesn't come out clear about what your answer may have been. In addition, please wait for anyone questioning you to complete their question before you speak, so two people aren't talking at the same time, which is difficult for the court reporter. Importantly here, if any answer to any question that's raised would be embarrassing for you to answer publicly, let us know, and we will have an opportunity to discuss those matters with you individually in a more private setting outside the presence of your fellow jurors. Also, in this case, there's been a lot of pretrial publicity and media attention, and there will be a section of the case where we'll be discussing that, but for those of you who have been exposed to some of that publicity or have some knowledge about this case through that, please don't discuss any details during your questioning here in front of the other jurors, so that those jurors who do not have that information don't hear it from you for the first time. We'll take those up individually with each of you when we're further into the process here, and allow you an opportunity to explain that more fully. At this time also, I'll instruct the attorneys to please avoid repeating any questions the court's already asked, but the attorneys do have the right to direct any follow-up questions to a juror regarding that juror's response to any previous questions of the court during voir dire. I'll next talk about the nature and purpose of juror challenges. The jury should be aware that during and following this voir dire examination, one or more of you may be challenged. Each side has challenges called for cause, by which I mean each side can ask a juror be excused for some specific reason. In addition, the sides will have a number of what are called peremptory challenges, and those are challenges that each side can exercise without giving any reason for the dismissal. If you are excused by either side, please do not feel offended or feel that your honesty or integrity has been questioned, because it has not. At this time, then, the court will commence with its voir dire examination, after which the attorneys for both parties will be given an opportunity to make their own inquiries.
Grandpa, when I sound the bird, I pray.
Question I will ask then, as it relates to your questionnaires you completed when you came here last week. I'll ask you as a group, are the answers contained in your questionnaires still true and accurate to the best of your knowledge at this time? Okay, thank you. Let me ask a question now as it relates to the time commitment that will be required if you are serving as a juror in this case. If you are required to serve as a juror here, it will be for a period of time that the attorneys have estimated to be 8 weeks. And the question is whether or not that service for that time would create a serious hardship upon you or your family or your business or profession or occupation, so as to prevent you from rendering service as a fair and impartial juror in this case. So if anyone has a response on that time commitment and a concern they believe would create a hardship, would you please raise your red card? Okay, we've got 3. Jurors 1571, 1266, and 1569. All right, thank you for that. I'll review your questionnaires briefly and then take up those questions with you individually, also potentially allowing the attorneys to respond on that issue. So let's start with juror number 1266. If you'd raise your card again, please. All right, thank you. I note in your questionnaire, juror 1266, you didn't check or explain a hardship there. Is there something that you'd like to advise the court of at this time on that issue?
I'm the sole breadwinner in our home, and I'm taking care of my wife. She's ill. And my mother-in-law lives with us, and I take care of both of them. And if I'm out for 2 months, there ain't going to be any money coming into that household. And I'm going to have a lot of bills piled up by the end of that.
All right, let me take a quick look at your... you still have the occupation of a supervisor of a shop?
Yes, sir.
And if you are not there working, you don't get paid. Is that accurate?
That's right.
Okay. Did you discuss at all with your employer the possibility that you may be required to serve here?
Yes.
Did they indicate they could make any kind of accommodation for you?
They were thinking about it. They say that for this week here, they're going to give me some time, but if I go on longer than that, I'll probably have to take all my vacation and then whatever else I got.
Okay. And could you explain a little bit more about the other part of the hardship beyond the financial side of who you're taking care of?
My wife.
Okay. All right, I'll allow for some follow-up voir dire on that specific reference for both the state and the defense as to juror 1266 on their request for excusal for hardship. Does the state have any questions?
Your Honor, the state has no objection to excusing juror 1266 for hardship.
All right. Would the defense like to ask any questions?
Your Honor, the defense has no objection to excusing juror 1266.
Okay. Based on those responses, as well as this court's review of your responses today in your questionnaire, I'll allow you to be excused, finding that it would constitute an undue hardship for you to have to serve in this case, given the length of the trial. I'll let you know something before you go, and if any other jurors are excused for any reason, please keep this in mind also. So that will complete your service as a juror in this case, and we appreciate your time coming in, filling out the questionnaire, and being here today. If you decide to discuss this case with anyone, be careful to respect the privacy and feelings of your fellow jurors, and please limit your comments to your own perceptions and feelings. If someone persists in discussing this case over your objection or becomes critical of your service for any reason, please report that to the court, and we may follow up on that issue. So I appreciate your time coming in today, and you can be excused. Next juror I'll discuss the hardship issue with is juror 1569. All right. All right, in this questionnaire also, I didn't see any explanation as it related to hardship. So juror number 1569, would you indicate to the court why you believe it would be a hardship for you to serve in this case?
I just received word this morning from my human resource department that they would only allow 30 days. And anything beyond that, I would not receive compensation.
Okay, if this trial were to go for roughly twice that length of time for 8 weeks, do you believe it would pose a financial hardship that would be an undue burden for you?
I do.
All right, thank you for that follow-up information you received from your employer. Let me ask the state if the state has any questions and wants any follow-up or dire with this juror.
You curious to see how I got paid $2,300?
This is basically the state asking citizens to sacrifice 2 months of salary. One of the richest countries in the world. One of the richest countries in the world. I got a toothache too, Marlawn, on my fucking nerves. 3 hours worth of work for nothing. Because it was, I think it was too good for you or what? That fucking toothache too. It's a shame that the richest country in the world turn to its citizens and ask to give up 2 weeks of income to do the government a favor.
Based on that information, the state has no objection to excusing this juror for cause.
Thank you, Mr. Wood. Mr. Archibald, do you have any voir dire for the juror?
No, we do not object to juror 1569 being excused.
All right. The court's reviewed that response as well. I do find that based on your response given today that serving for the entire period of this trial would constitute an undue hardship for you. So for that reason, you can be excused. Thank you for your service, and the same admonishment I gave the other juror about.
Not only do they tax the shit out of us, randomly they ask us to give up what's that? Like 15% of your yearly income to do the government a favor. If you want to support me, find out what makes me tick, please check out my autobiography, The Edict of Marlawn, The Cult of the Individual, by Marlawn Heavenly VII. Everywhere books are available, Walmart.com, Walmart app, Amazon. The Edict of Marlawn.
Who you discussed the case with or reporting to the court any unwanted contact will apply as well, so you can be excused, and thank you for coming. All right, finally, juror number 1571. All right, Juror number 1571, I've reviewed your questionnaire. You didn't expressly indicate a reason why it would be a hardship then. Would you describe to the court why you feel it would be a hardship if you had to serve in this case?
I'm just in a difficult situation. I'm unemployed right now. I'm trying to find work. I didn't state it because I'm not quite sure. I'm having a hard time getting interviews and things like that, and so as far as the time frame, I don't have any resources at this particular point in time. So I could, I guess, technically serve, but it will prevent me from finding anything. So that's why I didn't state it. I'm not quite sure because I'm in this difficult spot. I just don't have any resources coming in.
All right. I'd ask the state if there's any follow-up for Dyer for Juror 1571.
No, Your Honor. Based on the representations of this juror today and in the questionnaire, the state has no objection to excusing this juror for hardship.
All right. Mr. Archibald for the defense.
Your Honor, we do not object to Juror 1571 being excused.
Very well. The court's reviewed the questionnaire as well as the responses provided by this juror. I do find that it would constitute an undue hardship for this particular juror to serve at this time given the length of the trial and his unknown employment situation and efforts to find employment. For those reasons, then, Juror 1571.
We already down to, 11 of this batch? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. We're already down to 11 already.
Thanks of the court. You may also be excused in this case with the same admonishment given to those previous jurors about contacts once you leave. Do you have any questions about that? No. Okay. Thank you so much for appearing today. Then you can be dismissed, and we will move on to further questioning. All right. It's my understanding those were the responses as it related to any difficulty with the time commitment. Was there any other juror that had any issue to raise on that matter? All right. I'll next just briefly make an overview regarding the knowledge of the case. We'll come back to that topic, as I mentioned, individually for each of you. However, in order to get the list of who we're going to talk to about that, let me just ask here of this jury pool, who here both indicated on their questionnaire and would say today that you have had no prior knowledge of this case through any of the media reporting in the case. All right, so jurors 1238 and 1370. Thank you for that. We'll discuss the issue of that later individually with the rest, also 1758. And 1210. Okay. We'll also review your questionnaires, and if either of the parties have any follow-up questions, those can be brought up as well. Let me next move on to the issue of the subject matter of this case. I explained already the nature of the charges in this case, but reiterating that the charges here involve charges of murder, conspiracy, and theft. Is there anything about the nature of those charges in this case that would make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and render a fair and impartial verdict?
You're up with Venom Steel.
All right, no one answered affirmatively to that. I'll ask some further questions here, which you'll probably think should be obvious by what you said in your questionnaire, but I need to ask those to cover legal challenges pursuant to Idaho law. In regards to any relation to or acquaintance with the defendant, Are any of you related by blood or marriage to the defendant, or do you know her from any business or social relationship? Okay, no one responded to that question. Does the relationship of guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger exist between any of you or any of the attorneys in this case? Are any of you, and I'll note on the record there was no response to that question, are any of you a party in any civil action against the defendant in this case? There was no response to that question. Have any of you ever brought a criminal complaint against the defendant, or have you ever been accused of a crime, of a crime by any of the prosecutors in this case, including Ms. Blake or Mr. Wood? Okay, there was no response to that. I'll next discuss whether there's any representation or relation by the attorneys. The question is whether any of you have an attorney-client relationship with any of the attorneys or with their law firms. So in order to fully answer that question, at this time I'll ask the prosecutors to introduce themselves again and indicate who they work with in their office, and then I'll ask the same of the defense. So starting with Ms. Blake, who's in your office, and then we'll move on to Mr. Wood. Or,
Your Honor, if it's all right, I'll just answer for both of our offices.
yes.
Rob Wood, Madison County Prosecutor, and in that office we have Mackenzie Cole, Spencer Rammel, Adam Garvin, Troy Evans, and as stated by the court, we've deputized Rachel Smith to help with this case. In the Fremont County Prosecutor's Office, there is Lindsay Blake, Tanya Rawlings, Rocky Wixom, and Blake Hall.
All right, thank you, Mr. Wood. For the defense, Mr. Archibald.
I'm the sole proprietor.
All right, and Mr. Thomas, who do you work with in your office?
There is Jordan Crane, Jason Gustavus, Timothy French, Alex Sosa, Tyler Salveson, Brad Rigby, Paul Butikofer, and Justin Bowles.
Thank you. Now that the counsel have indicated who all they work with, let me ask the question again. Do any of you as jurors have any attorney-client relationship with any of the attorneys here or anyone mentioned that they work with? All right, there was no answer to that question from any juror. Are any of you jurors related by blood or marriage to any of the lawyers in this case, or do any of you know any of the lawyers from some prior professional, business, or social relationship? Okay, no one answered affirmatively to that. Let me next ask a question relating to whether you have prior jury experience. If you've previously sat on a jury that went through a trial, would you please raise your red card? Okay, 1133. Has anyone else previously served on a jury? Okay. Juror number 1133, would you just explain when the case occurred, where it was, and if you recall what the outcome was? Was it a criminal or civil case?
Yeah, it was a civil case, and I think it was approximately about 20 years ago, and it was like a car accident type of case, and it was a non-guilty verdict.
Okay, and do you recall where that was that you served?
It was in El Dorado Hills, California.
Okay. Is there anything about your prior service on that jury that you think would affect your ability to sit as an impartial juror in this case now?
No.
Okay, thank you for your response there. I'll next ask a general opinion to the jurors, but a obviously important question. Have any of you ever formed or expressed an unqualified opinion that the defendant, Mrs. Vallow Daybell, is guilty or not guilty of the offense charged? was no response to that question. Do any of you have any bias or prejudice either for or against the defendant in this case? Okay, no one answered affirmatively there. When you completed your questionnaires, there was a list of potential witnesses in this case. Those can be reviewed by counsel within the questionnaire, but I'll just ask you as a group, are the answers you provided in that questionnaire still accurate to the best of your knowledge as it relates to any witnesses you may know? Okay, thank you. Is there anyone here in this jury pool who would be unwilling to follow my instructions to you, the jury, as to the law that you must apply in determining this case? Okay, no one answered that question. Do any of you have a religious or moral position that would make it impossible to sit in judgment of another or to render a fair and impartial verdict in this case? All right, no one answered yes to that. Are there any of you that, if selected as a juror in this case, would be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the law as instructed by the court? Okay, no one had an affirmative response to that question. And then finally, do any of you have any other reason why you believe you cannot give this case your undivided attention and render a fair and impartial verdict? Okay, no one responded to that question either. At this time then, the court will pass its voir dire to counsel for their voir dire in the case, beginning with the state.
Thank you, ladies and gentlemen. Again, my name is Rob Wood. I represent the people of Idaho in Madison County. Just really briefly, if any of you thought it was strange that there's two county prosecutors here, as you may or may not have noted when the court read the indictment.
Tell the truth. You was fucking up, Mr. Woods.
The other day, and then summarized it again today, there are allegations that crimes were committed both in Fremont and Madison County. So that's why there's two county prosecutors here. Before I get into any questions, just wanted to reiterate, if you do have anything you feel like you need to tell us, but you think it might be embarrassing or it's just really personal, please just let us know, and we can do it individually. We want everyone to feel like they can answer everything honestly and totally. And so, speaking of that, I want to talk to you about the phrase brutal honesty. Juror 1276. If I ask you, you're all right. If I ask you, what does brutal honesty mean? What is your response?
Giving the truth regardless of what the result will be.
Okay. What about juror 1210?
Well, Mr. Woods, I tell you what it's not. It's not talking to the witness behind the scenes, telling them why it's a good idea they side with you before taking their statement. How about that, Mr. Woods?
What does that mean to you, brutal honesty?
Giving the truth without regard to someone else's feelings.
Okay. Thank you. And the reason I'm asking that, there's a defendant here today who's been charged with very serious crimes, and she is absolutely entitled to a fair and impartial jury. And
what about prosecutions? What about taping a conversation between her and her lawyer, Mr. Woods? How about that?
Fair and impartial trial. And we have to rely on what you tell us to make sure that happens. not only is she entitled to a fair and impartial trial, the people of the state of Idaho are also entitled to a fair and impartial trial. And so it's too important to the defendant, it's too important to the people of Idaho to not have honest answers. And I would add, to me, part of that is complete answers. So please make sure that you give us a complete answer. Just a real brief analogy. Who here has flown on a plane? I think everyone raised their hand. We all know how it goes. You get on the plane, you stow your luggage, and the pilot tells you, we're going to land at such and such place at such and such time. How many of you would feel comfortable if a pilot said, I might be able to land this plane? Nobody would feel comfortable, right? Because he's not getting you where he's supposed to get you. He's not doing what he needs to do. So, ladies and gentlemen, today you're the pilot. And when you're answering the questions, we need you to land the plane. And what I mean by that is that you give us those true and unvarnished answers. The judge spoke just very briefly about will you follow the law as it's given to you? Who here can think of a law or a rule at work or some regulation they don't particularly care for? By raise of hands. Almost everybody. Almost everyone can think of a law or rule they don't care for. And that's fine, because we all have different opinions. And we all think different things are fair. But what one person thinks is fair is different than what another person thinks is fair. And so for the defendant and for the people of Idaho to have a fair trial, there has to be an objective rule of law. And we all have to agree to abide by that law. And so when the judge gives you the instructions, it's possible you may not like the law. Can everybody here commit that whether you agree with the law or not, that you will follow the law as given to you by the judge or by the court in this trial? Can you raise your hands and commit to that? Thank you. And that might come up a little more later, but the judge spoke about pretrial publicity. Juror 1323.
This is the Patriot Power Sidekick.
Do you believe everything you see on the internet?
Do I what?
Believe everything you see or read on the internet?
Absolutely not.
Absolutely not. Why not?
Because not everything out there is true. Some people put out fake stuff, true stuff. So, no, I don't always believe what I see.
Okay.
I do my own research into it if I'm wondering if, whatever I see, and then form my own opinion.
Okay. Is there anybody here who disagrees with Juror 1323? Juror 1273.
Yes.
Do you believe everything you see on TV?
No.
You sound pretty emphatic.
Yes.
Why is that?
Because television is meant for entertainment. It's meant to sensationalize. It's meant to keep you engrossed and coming back, and things like that require something that captivates the audience. Mm-hmm. And so it's not always going to be true. It's going to be something that's going to hook you and make you want to come back.
Okay. Does anybody disagree with your 1273? No? No, I'm not seeing anybody raise their hand. Okay. And so, as the judge has said, and as we will talk about later, there has been a fair amount of pretrial publicity about this case. Can everyone here commit that you will put aside everything you've learned from the media or outside sources and only make a decision in this case based on information received in this court. I raise a hand. Can everybody commit to doing that?
Donations from the Sherlock Nation is the gas station of this operation. For me to stay subscription and paywall free and to keep my commercials at a minimum while helping me stay independent and focused. My address, PayPal, Venmo, and Cash App is in the information box. Leaving a 5-star review will help just as much. It takes a cult to raise an independent podcast. The only way I could fail is from lack of support.
Okay. I'm going to briefly speak, and the judge mentioned this, the nature of the case. The defendant in this case is charged with the murder of 3 individuals and conspiracy to commit murder. 2 of those individuals are minor children. In your questionnaire, you were asked if it would bother you to see autopsy photos. And so some of the evidence in this case will be, I'm going to use the words emotionally charged, and difficult to look at. Juror 1106. Just me telling you that, how do you feel about that?
I have seen a dead body before, so that's how I feel. You know, I knew how I reacted to that, which was fine, and I had to deal with what I needed to take care of with it. I went to somebody's house. I thought they were having a problem, and somebody was actually had died, and so I had to. You want me to tell the whole story?
Just briefly.
Briefly. So it was refugees that I work with. They didn't speak English. I didn't speak their language. The coroner was there, and they wanted somebody to get those people off the body because they needed to take it. And that was me. So that was probably, one experience that I've had was walking in and not expecting it and seeing a body.
So you've had some experience then with something similar to that.
Yes.
So we need the jurors on this case, both the defendant and the people of Idaho need the jurors on this case to act with common sense and reason. So juror 1106, if you see images or evidence that is emotionally charged, do you have any concerns that your response to that will overrun your reason and common sense in making a decision?
I have no reason to think that, no.
Okay. Is there anyone here who thinks that seeing that type of evidence, emotionally charged evidence, such as an autopsy photo, will overrun their reason and common sense in making a decision? This is where that brutal honesty comes in. I'm not seeing anybody raise their hand. Okay. Is there anyone here who will, let me ask it this way, can everybody here commit that seeing that information, that you will still consider all the other evidence in the case and not make a decision just based on that emotionally charged evidence? Okay, everyone who feels like they can do that, can you raise your hand? Okay, and you can do that. Okay, thank you. I'm going to turn the time over to my colleague, Ms. Smith, and she's going to ask a few more questions. Thank you.
Good afternoon. I'm going to follow up briefly on some things. I'm going to talk about some of your questionnaires, okay? Let's just talk. Let me turn quickly to Juror 1106. In looking at your questionnaire, there were some questions where I think you marked on there that you didn't understand some of the issues about beyond a reasonable doubt. Do I have that right?
That's correct.
Okay. Now, did you hear the court's instruction on that issue?
Yes.
Okay. Did that help clear it up?
No, to be honest with you, no.
Okay, fair enough. And it's hard, especially, I'm a visual learner, so if I don't see it. So let's talk about it a little bit. I also see, let me make sure I have my right juror, that you work in a pharmacy, correct? You're a pharmacy operations supervisor?
I'm not a supervisor. I work in health insurance and pharmacy in our pharmacy department.
Okay. Do you actually work where narcotics are stored, or are you more in an office?
No, I work from home. Not any longer. I have in the past, but no.
Okay.
I do not work around medicine.
Okay. Let's do this. Let's say that you were with a visiting relatives and there were some children present. Okay? And the children were told to stay away from the cookie jar in the kitchen. Okay? And every adult made it really clear, stay away from that cookie jar. And then you come into the kitchen and you see one of the very delightfully cute little kids standing there, and the cookie jar's open. There's crumbs on their hands. There's chocolate on their face, right? And it's, you look at them and you go, why did you eat that cookie? Right? Based on what you'd seen, would that firmly convince you that they had eaten that cookie?
No.
Okay. Why not?
Well, they just have crumbs. Maybe there were no cookies.
But there's chocolate on their
Hey. What's that? 1276. Wake up. Nope, I'm mailing it in. Fuck Marlawn. 1276. We gotta put something in her file for that. I'm gonna put I gotta put original thinker down. I guess she's an original thinker. She's not gonna let you. You're in trouble because you guys. Yeah, she gotta go. She gotta go. But she's an original thinker.
Her face.
Maybe it was remnants in the bottom of the cookie jar.
Okay. Okay. And so, if you saw those pieces sitting on their face and they wouldn't answer you when you said, "Hey, did you eat that cookie?" They just wouldn't talk. Would that help you be firmly convinced?
No, unless I seen them eat.
See, now I'm about to see if the prosecution got some teeth. Because if Pryor got a job at the court office and he was doing this, he would turn to the judge and say, "Get rid of her."
What I know.
Okay. So I think that it probably, that tells us a lot, because unless you see it or see an item, or unless I saw him do it, you couldn't make the decision that you couldn't be firmly convinced.
Correct.
Okay. Now let's extrapolate that to this situation. Are you going to be able to have people show you bits and pieces of things and reach a conclusion that leaves you firmly convinced that a crime occurred? Or do you have to see it?
I would say no, I do not have to see it. Because I would look at a bunch of different evidence and have to...
No, you found out you made the wrong answer. That is the same situation as the cookie reference. Stay consistent.
Make that decision from there. And if I wasn't 100%...
See, reasonable doubt is not 100%.
Then I could make that decision.
All right. If I wasn't 100%, you couldn't make that decision?
Yeah, if I wasn't 100%...
What's that? Who is she? 1-2... Fuck Marlawn. Who is that? 1276 original thinker. I'm gonna put she messed it up, but I don't think she's messed it up. But she's messed it up. I'm gonna put she's messed it up. I'm gonna put she's definitely going. She definitely won't be around. She definitely won't be around. I enjoyed it though. I like the honesty. And I like these. I don't like when they just lead you to an answer with these elementary examples.
% sure that child ate that cookie I can't say you ate that cookie.
Okay. Even if you received an instruction from the court saying, hey, if you're firmly convinced, even if it's not 100%, but you're firmly convinced based on logic and reason, and the court says you don't have to prove it to 100%, you don't have to remove all doubt.
That's probably where my answer was. I was a little bit confused on that questionnaire with that one.
Yeah.
For exactly what you're saying.
Right. And that's the reason, it's on, everything on that questionnaire is there for a reason. Because there are people who are like, Your Honor, Ms. Smith, I understand what the court's telling me, but I need to be 100%. I need to be more than firmly convinced. I want to see it. And do you think you're in that position where you need to see it?
I would, if I didn't see it happen, then I'd have to be convinced by other means, and that would be with the jurors, or in deliberation, that sort of thing. I would have to know.
All right. She's a tough cookie, pun intended. Fuck Marlawn. Thanks for supporting the Marlawn Podcast Network. 2 new episodes every day. Please check out my merch store. Link in the information box. My merch is my wardrobe. Yep, I'm selling shirts off my back, shoes off my feet, the pants off my ass. Own a piece of my personal life. I love those who love me. Let's finish. I want to hear this. this conundrum of bullshit. Like as if she's trying to lead her into saying what you want to hear, and she's just being honest.
No, I'll go back to the cookie thing. I'd have to, if it was that thing where I'd have to, hey, did anybody see this cookie? Or the kid eat the cookie? That sort of thing.
Okay. And so, without getting too far into the court's instruction, because we have to follow the instruction that's given us by the court, let me do it this way. A person who witnessed the child or anyone doing something, that person's a witness, right? Can a witness ever be a juror on a case that they're a witness on?
No.
Have you ever heard of that? No. I see lots of shakes of head. No, because so the person who's 100% because they saw it couldn't be a juror, could they?
I don't know law. I don't know.
Okay. Let me tell you, under the law, they can't. If you're a witness, you can't be on the jury. You can't see it, be a witness, and then also sit in judgment. Does that make sense?
That makes sense.
Right?
When you say it that way, yes.
Right. And so jurors are having to take evidence that is given to them and supplied in the courtroom, ruled admissible by the court, and consider that evidence, and then make a decision that leaves them firmly convinced. And so while a witness can be 100% certain of what happened, jurors have to be firmly convinced. Does that make sense?
Yes.
Okay.
Yes.
And only you know what's inside your head. Do you see the difference between those two things?
Yes, I do.
Okay. And only you will ever know, look, if I don't really see it, if I'm not 100%, I just don't think I could sit in judgment and consider convicting someone.
Maybe you don't know about the post-massage pack.
No. All right, we'll continue. She's gone. I like her, but she's gone, man. So we're gonna have to find a unhappy medium, man, because I'm sacrificing a lot to do this, man, and with the pressure to take the fun out and to be somebody I'm not, it's starting to get to me. I love those who love me. Catchphrase.
Rule. That's in our rules. If you want to see a copy of the rules, I'm sure Gene Hickey will show it to you.
You have a copy, Mr. Wintermeadow? You have 1 minute left. Do you have a copy? Yes, I do.
Ray,
Give me a free copy?
Ray, please. You're to address this counsel and not Mr. Wintermeadow,
can you give me a
please.
free copy of that?
We would be happy to make them available to you.
I want to see it.
Yeah, we'd be happy to do that.
I want to see this.
But please, you're a gentleman. You always come here and conduct yourself in an orderly fashion.
This because I went up to Dunmore, and they told me that they shouldn't have it. Now, they are angry about their counsel. I said, your counsel isn't as bad as our counsel.
Yeah, but all of this is irrelevant.
Our counsel is worse. I mean, they insult us. They belittle us. They don't give us respect. I mean,
once you get this money, and go have you a divorce party.
Sounds good.
All right, sweet pea, take care of yourself.
All right, darling. Thank you. I want to come.
Okay.
Bye-bye.
Bye-bye.
The power of the tarot awaits you. Cut the deck, unleash the mystery, and have your question answered.
Cleo is waiting for your call. Don't wait any longer. Call Cleo for your free tarot reading now.
Caller?
Yes, hi.
Hi, how are you, dear?
Good.
Good. Can I get your first name only and your birth date, please?
Maria.
Uh-huh.
And it's 9/26/62.
All right, Maria. You're a Libra, aren't you, darling?
Yes.
All right. Been going through some things lately, haven't you?
Last couple of years, yeah.
The last couple of years, bless your heart. I'm looking at a man.
Ray, you're getting a little off base here. You're not running the meeting, and you're not to dictate to Mr. Wintermail what his duties and responsibilities are.
I am a taxpayer. I have a right to say what I want to say.
No. You could say what you'd like to say within certain parameters.
I want to say because I dictate it.
No.
I pay
No, you
your
don't.
salary.
You don't.
You don't tell me what to do. I tell you what to do.
Mr. President, I would
order,
ask
Ray.
that he be removed.
You're out of order,
Okay,
Ray.
okay. I'm not tolerant.
Please, just try to get back on focus.
Kevin, I'm just saying, where does it say in the law there's a 5-minute rule? I just want to see it in black and white. Just show me in black and white where there's a 5-minute rule. Where does it say, with all your signatures?
It doesn't have to be in the law. It's the rules of council. The rules of council.
But you have to have it in paper.
Hey, Ray, could you give him the time to please explain?
You either fly, or you fry. Every try, you always lie. Every female, every guy. Don't try to escape and get high. Now I lay me down to sleep. What I did do not happen to me. It might seem like I'm rapping the beat. I pray the Lord my soul to keep. If I die before I wake, my apologies for heaven's sake. My inner space is outer space. Too bad it went down this way. Run DMC, then walk this way. Stairway to heaven on the hip-hop beat. Staring at heaven even if I sleep. Wake up from death 7 days a week. Consciousness is continuously. All I know is eternity. To be or not to be. The beat is feeling kinda deep to me. Is it you? It speak to me. Voices in my head play a symphony. Bach mixed with Tupac, Beethoven. I stay smoking. I'm really trying to quit, but I stay smoking. I really wanna hit, but I stay hoping. The day seems the same open. I really wanna change, I hope you notice. Forgive me for my sins when I lose focus. Forgive you, I hope you're joking. Karma came back and stuck his nose in. What you chosen is the chosen.